Presiding. Please be seated and briefing. Please be seated and briefing. Please be seated and briefing. Oh, please be seated and give us. Please be seated and.
I think we're good with please be seated. Good evening, ladies and gentlemen, and welcome to Mock Trial 2015. I know it's the first week. I know everybody's nervous. Shake it out, take a breath. Remember, you got into this for fun, and I promise you, it's going to be fun, all right? So, we're going to start. I'm going to introduce myself. We'll let the scorers introduce themselves, and then we'll really get moving. But take a breath. It's going to be all right. So, my name is Eric Lieberman. In real life, I am not a judge. I'm a criminal defense attorney. I also work as the managing attorney at this county's private defender program, which is our court-appointed indigent defense system. I've been practicing here in San Mateo County for about 32 years now. I coached a mock trial team myself up in Marin County for 8 years. I know how nervous you guys are. I know just how hard you've been working. Parents, if you haven't seen this before, you're about to be in for a real treat. So with that, I'm going to turn it over to the scorers and let them introduce themselves.
Hi, I'm Kathy Yolkin. I am one of the scorers tonight. I'm a criminal defense attorney in San Mateo County. I also, in my earlier life, worked as a prosecutor in San Mateo County, so I've done both sides. And I've been practicing law for a little over 30 years.
I am Steele. Basically I practice estates and trust law, everything from counseling clients to decisions in the Ninth Circuit Court of the U.S. Court of Appeals. I've been practicing around here for about 40 years. I've done a lot of looking forward to it.
Okay. So with that, unless there are any preliminary matters to address, I think you're ready for a team introduction.
Your Honor, may
Yes,
the
sir.
prosecution introduce themselves?
Please do.
Hello, my name is Joseph Alderson, A-L-D-E-R-S-O-N, and I will be the motion attorney for the prosecution. At this time, may the other attorneys introduce themselves?
Certainly.
Good evening, Your Honor. My name is Marinelle Lucero, spelled R-O-C-E-R-O. Tonight, I will be conducting the direct examination of Professor Marty McCulloch, cross-examining Sidney Ogden, and delivering the opening statement.
Good evening, Your Honor. My name is Justin Olagi, O-L-A-G-U-E. Tonight I will be conducting the direct examination of Detective Reese Barron and Bernie Worcester, as well as the cross-examination of T.M. Little and
Somebody else. There's somebody else.
yes.
Good evening, Your Honor. My name is Stephanie Barrow, spelled B-A-R-R-O-W. Tonight, I'll be conducting the direct examination of Charlie Gibbons, cross-examining Evan Shem, and directing the closing statement. At this time, may the witnesses introduce themselves.
Yes.
Good evening, Your Honor. My name is James Reed, spelled R-E-I-D, and tonight I will be portraying Detective Reese Barron.
Good evening, Your Honor. My name is Amanda McCool, spelled M-A-H-M-O-U-D, and tonight I will be portraying Professor Marty McCulloch.
Good evening, Your Honor. My name is Deepak Singh, S-I-N-G-H, and tonight I will be portraying Charlie Gibbons.
Good evening, Your Honor. My name is Taylor Womack, spelled W-O-M-A-C-K. And tonight I will be portraying Bernie Worcester. At this time, will the court clerk please introduce himself?
Yes.
Good evening, Ron. My name is Wilson Law, LA, and I'll be the court clerk for tonight. I'll be giving warnings at 2 minutes, 1 minute, 30 seconds, and time. Thank you, Your Honor.
Thank you.
Good evening, Your Honor. My name is Jack Hebb, H-E-B-B, and I will be representing Evan Shem and the defense. May my co-counsel introduce themselves?
Certainly.
Good evening, Your Honor. My name is Erica Hack, H-A-A-C-K. I will be performing the direct examination and cross-examination of all witnesses.
Good evening, Your Honor. My name is Nicole Laughlin, L-A-U-G-H-L-I-N, and I will be delivering the opening and closing statements. May my witnesses please introduce themselves?
Yes.
Good evening, Your Honor. My name is Emily Gomez, and I'll be playing Sydney Austin.
Good evening, Your Honor. My name is Leslie Valencia, V-A-L-E-N-C-I-A, and I will be playing T.M. Little.
Good evening, Your Honor. My name is Sophia Padua, P-A-D-U-A, and I'll be portraying Jamie Sardinia.
Good evening, Your Honor. I'm Jorge Lopez, L-O-P-E-Z, and I'm going to be portraying Evan Shem.
Are there any preliminary matters that we need to address prior to the beginning of the case? Hearing none, it is my understanding that there is a pretrial motion at issue. It is a motion to suppress evidence being brought by the defense. So I will hear from the defense first.
Your Honor, my name is Jack Hebb, and I am here to argue on behalf of the defense in the motion to suppress Exhibit B from evidence, and it is a handwritten note belonging to Evan Shem. The issue at hand is from the moment when Evan Shem's Fourth Amendment rights were violated when Detective Barron was unable to properly search Evan Shem's apartment and extended the search unrightfully into the carport adjacent to the apartment outside of the bounds of the apartment. Specifically, in his testimony, Evan Shem stated that permission was given to search his apartment. However, from further reading, it is revealed that Exhibit D was found not within the apartment, but from the carport outside of the apartment. Therefore, the extent of the voluntary search did not extend beyond the premises of the apartment. The Fourth Amendment of the United States Constitution states that it is the right of the people to be secure in their papers and effects against unreasonable searches and seizures. I do not believe that it is a reasonable conclusion that consent to search Shem's apartment extended beyond into the carport.
Well, he was a renter, not an owner, correct?
Mr. Gibbons.
Yes.
That is correct, Your Honor.
And part of what he rented with the apartment was this garage space area, correct?
I believe so.
So if that's all part of the same rental...
May I continue, Your Honor?
Yes, yes.
Okay.
But can you answer my question first?
I believe that the garage did also continue to... Excuse me, Your Honor. I believe that it may be true, it may be interpreted that Gibbons' stay in Evans' apartment may have also extended to the garage, and he may have had premises to act on that premises. However, witness, I apologize, Your Honor. Gibbons, at the time of the search, did not have, was not a co-occupant of the apartment, as he had been kicked out on June 30th, and the search took place on July 7th.
Okay, but Shem,
Yes.
the defendant in this case, he had told the police officer, hey, go ahead, look around, right?
Shem consented to a general search of the apartment. However, that did not extend down to the carport.
That's your position.
That is correct.
But why should I believe that position?
You should believe this position because, I'm sorry, Your Honor, I don't have to respond.
Now, the garage is a different structure, right?
I believe so.
But as I said earlier, it was all sort of part of the same rental. Is there some case that guides me to say that these should be considered different things as opposed to the same?
No. However, when Detective Barron was searching the apartment, he left the apartment to make sure he hadn't forgotten anything when he noticed the carport outside. And at this moment, he asked Mr. Gibbons if he could search the cabinet located inside the carport, at which Gibbons nodded and said, and told Detective Barron the location of the key. Detective Barron proceeded, in his testimony, Detective Barron claims that he proceeded to swipe the key to the cabinet in the carport from under Shem's nose, and because he did not explicitly ask the defendant to search the premises of the carport, I believe that this evidence should be stricken from the record.
Okay, you may proceed.
In the previous case of Illinois versus Rodriguez, it was determined that the drugs admitted into evidence did not violate the Fourth Amendment because Gail Fisher, the individual who informed the authorities, had ready access and control over the storage cabinet, as exemplified by his ability to present the key to the door. Because he was able to present the key to the door.
Well, let me ask you a question about that. Because the way I'm supposed to work as a judge is I'm supposed to look at these cases and see what
I understand, Your Honor.
So we're talking about presenting a key to the door. Now, we have Mr. Gibbons or Miss Gibbons, or we have Gibbons in the carport, doesn't hand over a key but says, hey, here's where the key is.
That's precisely my point, Your Honor. I'm very glad you pointed this out.
Okay, thank you.
I believe that in Illinois versus Rodriguez, because Gail Fisher says our apartment and he presents the authorities with the key, this demonstrates his credibility that the authorities would be able to conclude that he had the ability, he was a co-owner of the apartment.
And you're saying this case is
because Gibbons was unable to do so, Detective Barron could not prove beyond a reasonable doubt under his own suspicion that this was.
That's a good legal argument. You may proceed.
Thank you, Your Honor. Additionally, in the case of U.S. versus Davis, one of the two roommates gave consent to a general search of the mutually shared apartment. However, the evidence in question was excluded on the grounds that the defendant did not explicitly consent to a search of his room, and the consenting roommate did not have joint access over the duffel bag in question. This case applies to that of People versus Shem, and that neither the defendant nor Gibbons explicitly consented to a search of the storage cabinet located outside of the apartment. And Detective Barron had to slyly swipe away the key from under Shem's nose. Detective Barron clearly had the opportunity to ask Shem for permission to proceed with the search to the carport, but the detective decided not to.
And we don't really know why he didn't ask Shem to do it.
My suspicions conclude that he knew that this was not a just search. And that is why.
Well, and the cases tell me that sometimes it's an issue whether or not the officer is acting in good faith. Are you telling me that you don't think this officer
I don't think that Detective Barron was acting in good faith, because if he was, he could have easily asked Evan Shem for permission to use the key, but instead he neglected this and took the key without it.
Of course, the officer would have me believe that he didn't ask him just because he thought, hey, everything was okay. I saw this guy there, I thought he lived there. I thought this was all fine. You're not buying that, though, are you?
I do not.
You may proceed.
As a consequence to the lack of explicit consent to the search of the cabinet located, once again, clearly outside of the bounds of the apartment, any reference to or the admission of Exhibit D should be suppressed from evidence to uphold Evan Shem's constitutional rights. Thank you, Your Honor.
Thank you. I'm going to guess that the prosecution has a response to that.
Your Honor, may the prosecution enter well for the duration of the trial?
At will.
Your Honor, the search conducted by Detective Barron was constitutional. On July 7th, when Detective Barron went to Shem's apartment to ask to search it, Shem consented. After completing the search of the inside of the apartment, Detective Barron went outside to make sure he did not miss anything. While outside, he noticed a carport directly adjacent to the apartment. In the carport, he met Charlie Gibbons for the second time. Earlier, he'd observed Charlie Gibbons taking out what appeared to be the trash. And on this occasion, he observed Charlie Gibbons with his car parked in the reserved parking spot for the apartment. Also while in the carport, Detective Barron noticed a storage container. He asked Gibbons if the storage container belonged to the apartment and if he could search it. Gibbons replied, yes, it does belong to the apartment, and the key is in the kitchen. Detective Barron continued to get the key and search the storage container. This search was constitutional because not only did Detective Barron have consent from Shem to search the storage container, but also Gibbons.
Well, you said you had consent to search the storage container.
Yes.
You would agree, though, he didn't say, sure, you can search the storage container, correct?
When Gibbons told Detective Barron the location of the key, he implied that Detective Barron could search it. And because of that, Detective Barron was acting in good faith when he did it.
The officer made an assumption, right?
Yes, but it was a reasonable assumption in the context of the situation. May I continue?
Please do.
When Detective Barron asked Shem for the consent to search the apartment, he was asking for consent of the entire apartment area and could therefore search the storage container.
And how do I know that?
In the case, Florida versus Camino, police officers pulled over a man and asked the man if they could search the car. The man agreed to the search. While searching the car, the officers found a bag of drugs in the car. The defendant in that case argued that the drugs could not be used because it was not part of the car. But the court held that it could be. This is very similar to the case that we're looking at right now.
Or maybe it would be similar if he would have, after he was done searching the bag, went back to the guy's house and searched his garage. Because you're talking about a garage here, right?
Yes, it's part of the same the entity. And in the case, the important thing is that it's part of the same entity. And in this case, the carport is part of the same entity as the apartment. And because of that...
Different structures, though, right?
Yes, but as you said earlier, it's part of the same rent.
So you'd like that point.
Yes. And it's part of the same entity. May I continue?
Please do.
Also, Detective Barron had consent from Charlie Gibbons. Charlie Gibbons had been seen at the apartment on multiple occasions. He was there earlier, taking out what appeared to be the trash, and had his car parked in the apartment's parking spot. In fact, Gibbons used to be a roommate of Shem. But before Detective Barron conducted his search, Gibbons left the apartment. But there was no way that Detective Barron could know that.
So I really shouldn't consider that, right? What the detective didn't know or couldn't know.
He couldn't know. So what he observed, it was reasonable to believe that Gibbons was a co-occupant of the space and could consent to a search.
Let me ask you a question. This is an experienced police officer we're talking about, right?
Yes.
Well-trained, conducted a bunch of investigations.
Yeah.
How hard would it have been to say, are you saying yes, it is okay for me to search this area to get it.
Well, when Gibbons said that the key is in the kitchen, he implied that the Detective Baron could search the storage container. I don't believe
that brings me to my next question. So then he goes to get the key and he sees Shem.
I don't believe that he sees Shem. And I know what you're going to say. You're going to say, why didn't he ask Shem if he could search it?
That's exactly what I'm going to say.
He didn't need to because he already had consent from Shem to search the entire apartment area.
Well, that's really for me to decide, isn't it?
Yes, but the prosecution believes that when Shem consented to a search of the apartment, he consented to the entire apartment and the carport, which is part of the same rental as part of the search. So, the reason why Detective Baron didn't ask is because he already had consent, and there was no reason to bother Shem. And he had, not only did he have consent from Shem, he also had consent from Gibbons. So, he was acting in good faith because he had consent from two people to search the storage container.
Well, let me ask you this one. This may not be an easy question. The officer had encountered Gibbons before this,
That's correct.
when he found out some information about Shem. On that date, the officer said, do you mind if I look around? And Gibbons had told him no. So what should I make of it when he encounters Gibbons again, asks Gibbons again, and he gets the stuff about the key, but he doesn't get a yes out of it? Shouldn't that trouble him?
What Gibbons said before was for that time, but often people change their minds about whether or not a police officer can search an area. And at that time, Detective Baron believed that Gibbons had changed his mind because usually people do not tell a police officer the location of a key to a storage container if they do not intend to let the police officer search that storage container.
That's a good argument too. You make the same thing.
Thank you. To conclude, Detective Baron had consent not only from Shem, but also from Gibbons. When Detective Baron asked Shem if he could search the apartment, Shem agreed to the search, and because of that, gave Detective Baron the legal access to search everything. Also, Gibbons gave consent for Detective Baron to search the storage container. The prosecution would like to bring the case Illinois versus Rodriguez to your attention. In this case, a woman claimed to be living in a house and allowed the police officers in and said that there were drugs. Even though, in the end, it was determined that she was not actually a co-occupant of the house, but because she had the key and it was reasonable for the police officers to believe that she did belong to the apartment, the court held that the evidence found could be admitted into the case. Although Gibbons was not at the time a roommate, all the evidence that Detective Baron observed, him having his car parked in the reserved parking spot, taking out what appeared to be the trash, and knowing the location of the keys, made it reasonable for him to believe that he could search the apartment. And because of that, Gibbons' consent should hold. So, he had consent from Shem and Gibbons, and he was acting in good faith. Therefore, the evidence found in the storage container should be admitted into this case. Thank you.
Thank you.
May I respond, Your Honor?
Yes, please do.
The representative for my opponent referenced Florida versus Jimeno. However, I believe that this is appeal to a false analogy, because should this analogy be true, the garage would have been within the apartment, as was the bag in the car in the case of Florida versus Jimenez. Therefore, this is not a valid analogy, and thus a logical fallacy. Additionally, had Shem allowed Baron to search the carport, don't you think Shem would have guided the detective towards the key to assist, to facilitate the search of his premises? After all, Shem believes that he has done no wrong. This would only assist his case.
Well, isn't it reasonable, though, officer to believe when the person he's talking to, you mind if I search? And the guy says, go ahead. Isn't it fair for the officer to think, oh, this guy said I could search his stuff?
I don't believe so, because it was not the apartment. The carport was adjacent to the apartment, that is true. However, it was not the apartment.
But Shem didn't say you can search, but this apartment only. He didn't say that, did he?
I believe Detective Barron asked to search the apartment.
Okay.
He said so. Lastly, Your Honor, if Detective Barron was such a seasoned veteran police officer, why didn't he tell Shem that he intended to search the carport? I simply do not understand. That is all I have to say.
Are you saying he was obliged to tell him that?
I believe he was, as it was not the apartment.
Let's see what the prosecution has to say about that.
Your Honor, counsel for the defense said that there was a distinction between inside and outside in this case, but that's not really what the case, Florida versus Camino, was about. It's about whether or not the bag is the same entity as the car, and in this case, whether or not the carport and the storage container is part of the same entity as the apartment. And in this case, the storage container found in the carport is part of the same entity and should be included, and the evidence found in it should be included. Also, counsel for the defense asked why didn't Detective Barron ask Shem, and why didn't Shem guide Detective Barron to the storage container? Shem was doing other things. There was no reason for Detective Barron to bother Shem, and he'd already gotten consent from Shem and Gibbons to search the storage container. He was doing his job and trying to not intrusive to Shem.
When he had gotten consent from Shem, though, he didn't really even know about this garage unit, right? Because he only saw that when he stumbled onto Gibbons when he went outside, right?
That's correct, but also earlier he had observed Gibbons there and knew about, I'm sure he knew about the carport because he had been there earlier. And also, when Shem consented to the search of the apartment, he was consenting to the search of the apartment area and the entire rental unit. May I continue?
Yes.
Detective Barron was acting in good faith because he not only had consent from Shem, who consented to a search of the apartment, through the general consent to search, but also from Gibbons, who appeared to be the roommate of Shem. And because of that, Detective Barron was acting in good faith when Gibbons said, or implied, that Barron's could search the storage container. Because of this, the prosecution believes that the evidence found in the storage container should be admitted into this case. Thank you.
Thank you. I will deem this issue under submission. Sitting as judge, it is my job to review these cases, as you gentlemen have done, and apply what I believe to be the state of the law, factoring in the arguments. I find that I'm going to grant the defense motion, and this has nothing to do with quality of arguments. This is where I believe the law guides me, and I will say why. I think that an agreement by Shem to say, look around, doesn't necessarily mean look around anything I may own, wherever and wherever it is, and we are talking about a different structure. The trained officer sees somebody he recognizes and somewhat attaches to the apartment, but he never asks them, are you a resident here? And when he doesn't get a yes to search, he doesn't specify. And again, he's a trained officer, and perhaps most troubling is he then runs across Shem, who at least according to the case is just sitting there. He knows that Shem he's looking into. He knows that Shem lives there, but he doesn't even bother to ask Shem for his permission. So for all those reasons, I find the search of the garage area exceeded the consent that he had gotten from it, I'm going to grant the motion, and the parts of the case that are bracketed referencing those things at issue shall be omitted from the trial. That is my ruling. I will give each side a moment to reconfigure yourselves, and we'll start a trial.
Thank you, Your Honor.
The prosecution delivers opening statement.
Yes, it may.
Good evening, Your Honor. For swearing purposes, my name is Marinol Rosero, spelled R-O-C-E-R-O. The prosecutor representing the people of the state of California in this action. We are here because the defendant, Evan Shem, a student in financial trouble who wanted nothing but revenge on his teacher and employer, Professor McCulloch, decided to kill two birds with one stone by stealing the professor's prize painting, ironically named Treason. The defendant is an art student studying at California University with an uncanny ability to copy artwork. Professor McCulloch was also the defendant's professor. After every class, the defendant and Professor McCulloch would have deep discussions of art, discussing art and the Shem's own work. And when Professor McCulloch noticed the deep passion of art the defendant had, she decided to offer the defendant an unpaid internship in painting and preserving her art gallery. But the defendant was already in financial trouble. As an undergraduate student, the defendant acquired $50,000 in debt and is anticipating $75,000 more for his undergraduate degree. And when the defendant later learned that Professor McCulloch would no longer start paying a salary for the internship, the defendant was furious. You will hear from Professor McCulloch that shortly after beginning to work at Professor McCulloch's estate, the defendant was observed to be obsessed with treason. The painting, a work of Fletcher Yazoo, is of sentimental value to Professor McCulloch. Professor McCulloch's father had purchased the painting from Fletcher Yazoo himself, and Professor McCulloch had inherited the painting when her father had passed. Professor McCulloch will explain that she has had many conversations, deep conversations with the defendant himself of what the painting meant to her. And nearly every day, Professor McCulloch would see the defendant just staring at the painting, just gazing at it. As I have stated before, the defendant was observed to be obsessed with treason. Professor McCulloch, every year on the 4th of July, Professor McCulloch hosts a party and invites her friends to her estate. On the day of the 4th of July party, Professor McCulloch had asked the defendant to be a docent at the party to escort guests and share his knowledge about the paintings. Evan Shebb was the only one who Professor McCulloch entrusted safety for gallery to. Evan Shebb was the only one who was supposed to lock the gallery at 9 p.m. sharp. You will hear testimony from Charlie Gibbons that the defendant was seen suspiciously running near the gallery at 9 p.m. shortly after the fireworks display had started. The defendant was seen clutching a backpack that the defendant had no reason to be carrying. On the morning after the party, Professor McCulloch went into her gallery to look at treason. The painting failed to elicit its familiar emotional response. Her suspicions that something was wrong were confirmed when she received a call from a local art auction house asking about an offer to sell treason. You will hear testimony from Charlie Gibbons that he had overheard the defendant talking to the same local art auction house, asking about the values of treason and using a fake voice. It turns out that treason was just enough to cover almost all of the defendant's debts. In any case, Professor McCulloch immediately informed the police of her discoveries. Evan Shem was the only one that Professor McCulloch had entrusted the safety of the gallery to. Evan Shem was the only one who knew about the
Thank you. Does the defense have an opening statement at this time?
Yes, Your Honor. Good evening. My name is Nicole Lawson, Laughlin, representing Evan Schiff. On July 4th, Martin McCullough hosted his annual 4th of July party, and over 200 guests attended that party. And it was accused that Evan Shem is now in possession of treason located in his apartment from that same night on July 4th. Today, the defense will present you with a series of reasonings. First, over 200 guests attended that party, and Evan was instructed to supervise all the guests that were entering through the gallery where the painting treason was located. And that is a relatively hard thing to do for one person to watch everybody to do. Second, the painting located in McCullough's gallery is the authentic and was never taken in the first place. Therefore, the painting located in Evan Shem's apartment is a copy. Third, the evidence will show that Evan Shem is a very artistic person and is more than capable of copying the painting treated, but for his own use in his apartment. And last, there was a certain guest that was distant from the crowd on the porch watching those fireworks. That guest was headed towards the gallery where the treason was located, and that guest is Charlie Gibbons. Today, the prosecution will attempt to tell you that Evan Shem has taken the painting treason on the night of July 4th. But I am here to tell you that that is indeed false information, and the painting was never taken in the first place. With that being said, the painting was never taken in the first place, and my client, Evan Shem, is not guilty. Thank you.
Thank you. The prosecution, they call that first witness.
Your Honor, the prosecution would like to call the witness, Detective Reese Barron.
Thank you.
For scoring purposes, my name is Justin Olague, O-L-A-G-U-E.
Certainly.
Do you solemnly affirm that the statement you're about to give is truthfully and faithfully conform to the facts and laws of the North Carolina Constitution?
I do. And for scoring purposes, my name is James Reed, R-E-I-D. I'm the trained detective Reese Barron.
Your Honor, at this time, I would like to inform the court that I am part of the hearing and would like permission to ask witnesses and attorneys and yourself to repeat themselves as needed.
Certainly.
Good evening, Detective Barron.
Good evening.
Could you please describe your law enforcement experience for the court?
I'm a detective for the Hamiltonia Police Department, and for the last 16 years, I've specialized specifically in art crimes.
And how did you become involved in the case of the theft of treason?
Well, on July 5th, I responded to Marty McCulloch's call that treason was stolen and drove up to her gallery.
When you arrived at Professor McCulloch's mansion, what was your first course of action?
When I was at the gallery, I checked for any break-in points, and I could not find any, so I assumed it must have been an inside job.
Did you discover any suspects?
We received a guest list of everyone who attended the party at McCulloch's the previous night. However, my attention was drawn towards Evan Shem, who had been responsible for the gallery that the treason was stolen.
Could you please identify the defendant Evan Shem for the court?
Yes, that's Evan Shem on the left.
Your Honor, may the record show that Detective Barron identified Evan Shem?
The record shall so reflect.
What did you do to follow up your suspicions of Evan Shem?
On July 6th, I attempted to gain access to Evan Shem's apartment, but I could not, so I returned on the 7th, which on that day I found would be confirmed to be the real treason. And on the 8th, I arrested Evan Shem.
Your Honor, may the witness have permission to approach the evidence?
Yes.
Detective Barron, do you recognize Exhibit A?
Yes, Exhibit A is the painting that I found at Evan Shem's apartment, and that be confirmed to be the real treason.
And do you
Objection,
recognize...
Your Honor. Speculation. Detective Barron is a lay witness. He has no expertise in identifying which painting in Exhibit A or Exhibit B is the real painting.
Your Honor, may I be heard?
Yes.
Detective Barron is not saying that he personally just identified that as the real treason. He is saying that that is the treason that was later identified as the real treason. He is not speculating. He is reiterating what he has discovered from an expert who has done a thorough, in-depth analysis of these paintings.
It may be what he meant, but it's not what he said, and the objection is sustained.
Do you recognize Exhibit A?
Yes, Exhibit B, Exhibit A?
Yes.
Exhibit A is the painting that I found at Evan Shem's apartment.
And what was discovered about Exhibit A?
Well, I brought Exhibit A back to the department, at which point it was confirmed by Bernie Worcester to be the real treason.
And do you recognize Exhibit B?
Exhibit B is the painting that I found at Marty McCulloch's mansion that was confirmed by Bernie Worcester to be a fake.
Thank you. Your Honor, may my witness please return to the stand?
Yes.
Your Honor, I would like to enter Exhibits A and B into evidence.
Any objection?
No, Your Honor.
They shall be received.
Thank you, Your Honor. No further questions?
Cross-examination.
Detective Barron, do you have any forensic evidence beyond Exhibits A and B that the defendant, Evan Shem, is guilty?
I do not have any forensic evidence, however, we found...
You have no eyewitnesses, and you have no fingerprints.
We cannot identify any fingerprints on the treason that we found in Marty McCulloch's mansion, however, Bernie Worcester confirmed that it was a fake.
So you had Bernie Worcester examine the painting, Exhibit B, correct?
Bernie Worcester and Marty McCulloch looked at Exhibit B.
And Worcester decided it was a fake.
Bernie Worcester confirmed that Exhibit B was a fake.
But this was before Exhibit A had ever been recovered, is that correct?
Correct.
So he did not compare them side by side while making his decision.
Bernie Worcester first found and confirmed that Exhibit B was a fake.
But he did not compare it to Exhibit A when he made that determination.
Not at the time, we did not have them side by side.
Have there ever been any photographs of treason that he could have used as comparison?
I don't believe there were any photographs of the paintings.
So the entirety of your investigation lies on Worcester's decision that Exhibit B is fake.
As well as the confirmation that Exhibit A was the real treason that I discovered at Evan Shem's apartment.
Which was again made by Mr. Worcester.
Correct, and Marty McCulloch.
You collected all of the information in the witness statements, did you not?
Correct.
And you failed to ask Charlie Gibbons, the only witness in the case with a history of theft and crime, if he was in the house during theft.
Correct, but correct.
No further questions, Your Honor.
Read the record.
Detective Barron, did you conduct a full and thorough investigation of the theft of treason?
I did.
And the result of that investigation was what?
We found what would later be confirmed the real treason and arrested Evan Shem.
Thank you, Your Honor. No further questions. May the witness please be excused?
Yes. Thank you, Detective. People may call the next one.
Your Honor, the prosecution calls Professor Marty McCullough to the stand.
Please solemnly affirm that the statement you are to give is truthfully and faithfully conformed to the facts and rules of contract competition.
I do. My name is Professor Marty McCullough, and for scoring purposes, my name is Anani Mahmoud, M-A-H-M-O-U-D.
For scoring purposes, my name is Marinol Lucero, spelled R-O-C-E-R-O. Good evening, Professor.
Good evening.
So, please state your age and profession to the court.
I am 52 years old, and I'm a professor of art history at Hamiltonian University.
So, who's the owner of the stolen painting?
I am the owner of Treason by Fletcher Avenue.
And how did you acquire treason?
I inherited it from my father when he passed away.
Jumping forward, how do you know Evan Shem?
Evan Shem was a student of mine at Hamiltonian University, and at the time I found it appropriate to offer him an internship at my mansion, so he was also a mentor.
At your mansion? How frequently did Evan Shem stare at treason?
Objection, Your Honor. Leading question.
Your Honor, this is not a leading question, for I'm asking why. How long Evan Shem has stared at treason?
I will suspend the objection and ask the counsel rephrase it.
Did Evan Shem... How long... Did Evan... I will check that question, Your Honor.
Okay.
So, what do you do on every year on the 4th of July?
Every 4th of July I have a party at my mansion.
And how many guests did you have in your 4th of July party, Professor?
There were nearly 200 guests.
And what guest stuck out the most to you?
Tim Little was caught me by surprise.
And who was Tim Little to you?
Tim Little was a person that I used to do art business with, but we recently had ended our business relationship.
When did you discover that you were painting treason mistakes?
The next morning when I went to look at treason like I do every single morning, I didn't get the same emotional response. And then I received a phone call pertaining to the price of treason, and that's when my suspicions were confirmed.
Your Honor, may the witness please approach Exhibit C?
Yes.
Professor, what is exhibit? Could you please explain to the court what Exhibit C is?
Exhibit C is an accurate diagram of my mansion.
Could you please show the court where the covered porch is?
The covered porch is located over here.
Where the living room is?
Yeah.
And where is the kitchen?
Located right here. Excuse me.
And where is your gallery, Professor? Professor, would it be possible to have seen anyone leaving the gallery, leading into the hallway from the covered porch?
There are two walls blocking any view from the covered porch. At most, someone would have to stand all the way at the edge in order to see someone either exiting from the bathroom or the hallway, but it's hard to tell.
Your Honor, I ask that Exhibit C to be moved into evidence and the court so admitted.
Any objection?
No, Your Honor.
Shall be received and added.
Your Honor, may the witness please return to her seat.
Yes.
Professor, how secure
gallery is very secure. There's a passcode to unlock it and another unique one to lock the gallery, which Evan Shem has used often.
And can you describe the phone call you had when you discovered your painting was the fake one?
Well, I was devastated when I found out that my most cherished painting was stolen, so I needed some emotional support and I decided to call Evan Shem. The response I got from Evan Shem was quite odd. He acted as if I was calling to accuse him when I merely wanted empathy.
No further questions, Your Honor.
Thank you. We have a cross-examination.
Yes, Your Honor. Is it true that in terms of money, Treason is not the most valuable painting compared to the rest of your collection?
In terms of money, no, but sentiment is the most valuable painting that I have.
You have paintings worth millions, do you not?
That's correct.
Treason is valuable to you because simply the sentimentality.
Yes, my father gave it to me when he passed away. It was a part of my childhood.
Except you aren't fond of the artistry, are you?
Treason is very significant to me.
But the artistry is not.
Never necessarily said that. The most important part to me is the sentiment that I have with it.
You think that it is quirky, and your appreciation of it is simply because it was belonging to your father.
Its unique style and the sentiment that I have with it makes me cherish the painting.
You decided that it was a forgery the morning of July 5th because something was strange about it.
I didn't get the same emotional response when I looked at it like I do every morning, and the phone call that I received confirmed my paintings. Of course, I didn't assume that the painting was a fake at first because it was in my gallery.
In your statement given just now for the
Objection, Your Honor. This testimony lacks foundation.
May I respond, Your Honor? In the testimony just given for the prosecution, you stated first that you observed the painting and determined that it was a fake, and second, you received a phone call regarding the value of selling Treason.
Yes, and then when I reevaluated my painting, I saw that some brush strokes were more controlled.
In your witness statement, you stated that first you received a phone call, and second determined that your painting was a fake.
First I had suspicions, then I received a phone call which confirmed my suspicions, and then when I reevaluated my painting, I saw that some brush strokes were more controlled.
When you determined that the painting was a fake, you made no technical analysis of the painting to identify discrepancies, even though you are an art expert yourself. Is that true?
I'm a professor of art history, but I didn't need to do anything. I looked at this painting every day, and it was part of my entire life. So when I just looked at it again, I saw that some brush strokes were more controlled, and that's all I needed.
Did you offer Evan an internship at your gallery?
That's correct, I did.
Did he prove to be a competent and loyal intern?
Yes, until I found out that he stole my most cherished painting.
Did you ever think of firing him before the morning of July 5th when you determined that your painting was a fake?
Not until I found out that he stole my painting.
Until you found out that he allegedly stole your painting.
Until I found out that he stole my painting.
No further questions.
Any redirect?
Yes, Your Honor. Professor McCulloch, how long have you had Treason?
Nearly my entire life.
No further questions, Your Honor. Oh, Your Honor, the prosecution calls for a time check.
There was 7 minutes and 27 seconds remaining.
Thank you, Your Honor.
Thank you for that.
May the witness please be excused from the stand?
Yes.
Sorry.
Any further prosecution witnesses?
Yes, Your Honor. The prosecution calls Charlie Gibbons to stand. And for scoring purposes, my name is Stephanie Barrow, B-A-R-R-O-W.
Do you solemnly affirm that this testimony you're about to give is truthfully and faithfully confirmed to the true facts and rules of the Montreal Constitution?
I My name is Deepak Singh, S-I-N-G-H, and my name is Charlie Gibbon.
Good evening, Mr. Gibbons.
Good evening.
How do you know Shem?
Well, we've been best friends since the 3rd grade, and we've been inseparable ever since, until we drifted apart in high school. But once he came back for graduate school, we instantly reconnected.
And what happened after you and the defendant reconnected?
I asked him if I could stay at his place for a while, and he graciously let me.
And what did you do while you stayed at the defendant's apartment?
Well, I looked for a job my entire stay there, but while I wasn't searching for a job, I decided to look through some of his art.
And what did you notice about the defendant's artwork?
He was really good at art. He could create masterpieces from memory.
What else happened while you stayed at the apartment?
I also noticed that he started talking about this one specific painting called Treason, and he just wouldn't stop talking about it.
And what happened when the defendant took the internship with McCullough?
He continued to talk about treason, and then I also overheard a call on the phone where he was thinking about selling it.
And did this conversation seem strange?
No.
Objection, Your Honor. Hearsay. In the case of the phone call, there is no confirmation in the witness statement that the call overheard by Mr. Gibbons is the same phone call made to Mr. Worcester about the value and selling of the painting. And therefore, because the other person at the end of the call is not able for testimony, and Mr. Gibbons is not a direct participant of the call, it is grounds for hearsay.
Your Honor, may I be heard?
Yes.
The witness is testifying what he overheard, and he's stating what he overheard the defendant said, and whatever the defendant said is admissible in court.
Any response to that?
Because the other end of the phone call was not heard, we have no evidence of what was said by the person on the other end of the phone. And so because they cannot be called for testimony, for cross-examination, to verify that what both Evan Shem and Charlie Gibbons say as an extra response is true.
I'm going to overrule the objection, but listen very carefully to the answer as to what the testimony is about whose words are being spoken.
Thank you, Your Honor.
You may ask.
Would you like me to repeat the question?
Yes, please.
What did this conversation seem on?
Well, it didn't, because whatever Shem was about to do, I didn't want any part of it because I'm not that kind of person anymore. And I knew, and I was just really tired of him talking about treason.
So tell me, Mr. Gibbons, what happened on the night of 4th of July at McCullough's party?
I decided to go see this painting, Treason, that Shem kept talking about. And once I saw it, I didn't really like it. It was a tacky and uninspiring painting. I don't know how he could have liked such a thing. And then afterwards, I went outside to go watch the fireworks.
Thank you, Your Honor. No further questions.
Cross-examination.
In high school, did you ever get in trouble with the law for theft?
Yes.
And you were fired from your previous job at the hardware store for stealing from your boss, were you not?
Very unjustly, because he didn't give me a chance to defend myself.
But you were fired because you stole from him.
Allegedly.
Is it true that you came to stay with Evan because you were unemployed and short of cash?
That is true.
Did you ask him if you could stay for a couple of weeks?
I did.
And did you end up staying for a couple of months?
I did, but then he let me, I moved out after a while.
You never paid him any rent, did you?
I did not.
So when he asked you to, you moved out and went to live with another friend, rent-free as well.
That is true.
Is it true that while you stayed with Evan, you failed to find a new job?
Well, I kept searching the entire time.
But you did fail.
That's true.
Were you Evan's +1 at the McCullough 4th of July party?
Yes.
Did you wear your trench coat to the party, even though it was a warm summer night?
Well, I thought it looked good with what I was wearing.
You stood to the rear of the crowd by the kitchen during the fireworks, correct?
That is true.
So you approached the exhibit and explained the position that you were standing at?
Well, I was standing towards the back, near the corner wall of the living room and the kitchen, so I could still look inside of the glass window down the hall.
Are you aware that Sydney Ogden has testified in her witness statement that she saw you inside, leaving the gallery during the fireworks?
Not aware.
Objection, Your Honor. This witness cannot testify what is in another witness's testimony.
I did not ask him if he can testify to what she said. I asked if he's aware that she mentioned where he was.
And he indicated he was not aware. That answer will stand. Objection overruled.
No further questions.
Any redirect?
Yes, Your Honor. First, may the witness be seated?
I don't see why not.
Mr. Gibbons, why were you wearing trench coat to party?
I thought it looked good with what I was wearing.
And was there any reason for you to steal treason?
Of course not. I didn't like the painting. It was tacky and uninspiring.
Did you steal treason, Mr. Gibbons?
No, I did not steal treason.
Thank you, Your Honor. No further questions. May this witness be excused.
You may. Does the prosecution have any further witnesses?
Yes, Your Honor. However, at this time, the prosecution would like to ask for a time check.
You have 5 minutes and 20 seconds.
Sir?
5 minutes and 20 seconds remaining.
Your Honor, at this time, the prosecution would like to call its last witness, Bernie Worcester.
Okay.
Do you solemnly affirm that the testimony you have to give is faithfully and truthfully conform to the facts and rules of international competition?
I do. For scoring purposes, my name is Taylor Womack, W-O-M-A-C-K. My name is Bernie Worcester.
Again, for scoring purposes, my name is Justin Olagi, O-L-A-G-U-E. Good evening, Mr. Worcester. Could you please tell your occupation to the court?
Currently, I'm employed at MT's Fine Art Auction House as the lead curator and receive calls on people looking to sell paintings worth hundreds of thousands to millions of dollars.
And what kind of education does one need to have a job like this?
I received my master's degree in art history from Notre Dame University in 1989, and over the last 25 years, I have continued my education by attending many nationwide seminars and forums on the latest research into art appraisal techniques.
How did you first hear about the painting Treason?
Before I was informed about the case, I received a phone call on July 2nd, someone inquiring as to what the cost of treason would be about on the market. I gave them our best estimate of about $100,000, and they seemed very excited at the news.
How did you become involved in the case of the theft of treason?
I am also retained from time to time by the Hamiltonia Police Department to assist in cases of forgery and art theft. And I was asked by Detective Reese Barron to determine the authenticity of a painting found at Professor McCulloch's gallery on July 5th.
Your Honor, at this time, I would like to remind the court of the stipulation that Bernie Worcester is an expert witness and should be treated as such.
I am so reminded.
Your Honor, at this time, I would also like to ask that the witness be allowed to approach the evidence.
Certainly.
Mr. Worcester, during your analysis of the paintings, what did you discover?
Well, as I first analyzed the painting Exhibit B found inside of Professor McCulloch's gallery on July 5th, I determined after a very careful visual examination, specifically through the method of Morellian analysis, that it is a fake.
And what about Exhibit A?
Once Exhibit A, the painting found inside Evan Shem's apartment, was found by the police department and brought back, and I was given time to carefully examine it, I was able to determine that it is the real treason painted by Fletcher Yazoo.
Could you please describe to the court how you arrived at these conclusions?
Well, the most important approach is that of connoisseurship, and as I stated, Morellian analysis. So, Fletcher Yazoo is known for his very vigorous painting style. He rarely ever gently applied paint to a canvas. He kind of attacked it in a way. He would normally leave rough edges. You could see the individual bristles leaving their remnants of paint on them. So if you look at the arrow shape at the top of the circle in Exhibit B, you'll see that the edges are much more full. It has much thicker and consistent paint throughout, which is not characteristic of Fletcher Yazoo's technique and signature brushstroke. As you can see, the same shape in Exhibit A, the painting found in Evan Shem's apartment, is not much more rough-edged, does not have consistent paint, and there are similar discrepancies with the arrow structure to the right, as well as the bone structures to the lower right of each painting. But the most important piece of evidence is the pink dot to the right of the original arrow found in Exhibit B. Now, in Exhibit B is a pink oval, something that was put on as an afterthought, characteristic of a copycat who almost got the painting right, but then realized they missed the one part and put it on afterwards. As you can see in the original painting found in Evan Shem's apartment, it is only a pink streak, which is characteristic of Fletcher Yazoo's style, as he would rarely completely rinse his brushes when changing from, say, red paint to white paint.
Mr. Worcester, what is your expert diagnosis as to the authenticity of these two paintings?
I can say with absolute confidence that the painting found in Professor McCulloch's gallery on July 5th is a fake treason, and the painting found in Evan Shem's apartment, Exhibit A, is the real treason by Fletcher Yazoo.
Thank you, Your Honor. No further questions made by witness. Please return to the stand.
Yes. Cross-examination.
Is it true, Mr. Worcester, that in the instance of connoisseurship, equally qualified experts can come to totally different opinions?
While there is sometimes room for debate
Yes or no,
and
please.
it is not that, it is more nuanced than that. While
Yes or
there is
no?
some...
Yes or no?
In,
Can two experts come to totally different
Objection,
opinions?
Your Honor. The witness is trying to explain why this is true, and it is important to the case. And so I believe that he'd be allowed to give a full explanation and answer as to why two experts can come to different conclusions.
I will allow the witness to explain his answer if he first answers her question.
May I respond, Your Honor?
Well, I'm sort of sustaining your objection. And you can ask the question, he gets to explain, but he gets to answer first.
Yes or no?
yes, but in the cases of very, very specific details, not one so clear and obvious as this.
If we invited 100 different experts to examine this case, could I potentially end up with 100 different opinions?
No, as there are only two options.
One of your determinations was the fact that the downward pointing white arrow shape shows stop-start evidence consistent with copyist painting, correct?
Yes, that is true. That is very consistent with a copier.
And this is because a copyist is looking back and forth between the photo or the original to what he's painting.
Or remembering the painting inside of his mind.
So if it had been done from memory, there would still be evidence of start-stop painting.
That is true. If the copyist had somewhat of a photographic memory and was remembering it and then continuing the painting, that is very possible.
Do you have any evidence that that Mr. Shem has a photographic memory?
No, I do not, as I have not done that analysis of that vision.
Would you agree that connoisseurship requires mastery and appreciation of an art form?
Absolutely. If someone does not have much experience, then their opinion should not be given much weight inside the artistic community.
Do you have any specialization in modern abstract painters?
No specialization, but I am very skilled in almost any genre of art.
Had you ever seen treason before the proceedings of this investigation?
I have not seen treason, though it is possible that over my 25 years of experience I've come across Fletcher Yazoo paintings before.
Are you aware that Detective Barron gave testimony regarding to your initial opinion at police headquarters on July 5th?
Sorry, may you repeat the question?
Are you aware that Detective Barron gave testimony regarding your initial opinion at police headquarters on July 5th?
Objection, Your Honor. Witnesses are not allowed to testify as to the testimony or the statements of other witnesses, except for the other witness, or except for the other expert.
May I respond?
Yes.
Mr. Worcester was present when Detective Barron gave his testimony, and if you had heard the testimony, you would be aware that there was discussion of his official determination at the police headquarters of July 5th.
Your Honor, may I respond?
Yes.
In the rules of mock trial, it states that no witnesses except for the experts are allowed to testify as to the others, or as to as to others' testimonies.
May I respond, Your Honor?
Yes.
I asked a yes or no question if he was aware that the testimony was given and not asked to respond to any details given in the testimony.
Your Honor, may I be heard?
No, I think I'm ready to rule on this. And I'm going to sustain the objection.
Exhibit A wasn't recovered until July 7th, so when you identified Exhibit B, you had not seen Exhibit A before.
That is true, but I became familiar with Fletcher Yazoo's technique in signature breaststroke.
No further questions, Your Honor.
Any redirect?
Yes. Mr. Worcester, how many years have you been authenticating art?
25.
And is there any other expert as qualified as you here tonight?
No, I do not believe so.
Thank you, Your Honor. No further questions. May the witness please be excused?
Yes. Any further witnesses for the people?
No, Your Honor.
Is the defense going to call any witnesses today?
Yes, Your Honor. The defense would like to call the defendant, Evan Shem, to the stand.
Recording purposes, Harvey Lopez, OPEZ, and
I would like to apologize to the explorers of the court for not introducing myself during cross-examination. For scoring purposes, I am Erica Hack, HAACK. May I proceed, Your Honor?
You may.
What is your educational background?
I got a bachelor's degree in Hamiltonia University.
Where are you employed?
I was currently employed in Macaulay's Gallery.
Do you have any hobbies?
Besides art, no.
Did you steal treason from your former employer?
No, I did not.
Did you make a forgery with intent to sell it as the original?
No, I did not.
Do you know Charlie Gibbons?
Yes, he was a childhood friend.
Did he ever live with you?
Yes. At first he said he was going to live for a couple of weeks, then it was months.
What do you know about his background?
In high school he used to steal from the school and the town.
When did he stop living with you?
Can you repeat the question?
When did he stop living with you?
I told him to move out by June 30th.
And did he move out?
Yes, but he still had some stuff in my apartment.
Did you allow him to keep the key to have access to his stuff?
Yes, I did.
With the key, would he have also had access to your apartment?
Yes, he did.
Did Charlie attend McCullough's 4th of July party with you?
Yes, he insisted to attend.
How did you meet Marty McCullough?
He's my professor.
And how did you come to work for him?
He asked for an internship.
Did you like your internship?
Yes, I did.
What was your role at the 4th of July party?
I was supposed to supervise his artwork and then lock the room after.
Where were you during the fireworks?
During the fireworks, I was watching the fireworks.
Did anything happen into the fireworks?
I remembered I forgot to lock the room.
How long did you?
It was about 10 to 15 minutes.
Is there anything more that you would like the court to know about your involvement?
That I did not steal this painting.
No further questions.
Prosecution's cross-examination.
Yes.
You're a graduate student at Hamiltonia University, correct?
Yes.
And you assume that you'll acquire $125,000 worth of debt by the time you graduate?
Yes.
And you took Professor McCullough's internship so you could help pay back your debt?
At first I took the internship, and then he told me I could have worked with him.
So were you angry when Professor McCullough's promise of payment never materialized?
I was alone.
And you even said this marked the turning point in your relationship.
Yes.
And while working with Professor McCullough, you became specifically interested in treason, didn't you?
Yes, I did.
You even stated that it had a hypnotic quality to it, didn't you?
I don't recall.
You don't recall? Your Honor, may I approach the witness?
You may.
Will you please read on page 34, line 10?
It had a hypnotic quality.
So, did you state that treatment had a hypnotic quality?
Yes, it did.
And you even contacted MT's Fine Art Auction House to find out the value of treason, didn't you?
Yes, I did.
And how much did you find out it was worth?
$100,000.
And that amount of money could pay back all of your college loans and almost all of your graduate loans?
Yes.
You also recreate famous paintings, don't you?
Yes, I do.
And you're good at these recreations?
Yes, I
You even created a replica of treason, didn't you?
am. Yes, I do.
On the night of McCullough's 4th of July party, you were asked to be a docent for the evening,
Yes, I did.
and you brought a backpack to this party.
Yes, I did.
And when questioned about the backpack, you stated that it was being used to carry art supplies around, didn't you?
Yes.
And when questioned about the sketch that you were supposed to be making by T.M. Little, you stated the sketch was going great, didn't you?
Yes, I did.
But you didn't sketch anything, did you? Was there any reason for you to lie to T.M. Little?
No.
And at this point, you claim to have just finished locking up the gallery, didn't you?
Yes.
So your duties were done for the night,
Yes.
and then you went almost immediately home.
Yes.
Thank you, Your Honor. No further questions.
Redirect, Your Honor.
Yes.
Why did you call the MC auction house?
To find out what its value was,
For what reason?
to show the professor that it was valuable.
Was Mr. McCullough aware of your ability to recreate famous artworks?
Yes, it was.
Did you ever bring them to him?
Yes, I did.
For what reason?
To get judged by it, to see how good I was.
No further questions, Your Honor. May the witness step down.
Yes. And the defense may go over the next witness. Thank you.
The defense would like to call Jamie Sardegna to the stand. May I have a time check?
You have 11 minutes and 17 seconds remaining.
You solemnly affirm that stating your facts is truthfully and faithfully conformed to
We buy and resell artwork to help.
Are you currently on good terms with Mr. McCullough?
No,
For what reason?
we had a fallout after he failed to reimburse me for an art piece.
Despite this, did you still attend the 4th of July party?
I did.
For what reason?
I couldn't risk to lose any of my clients as there was many other art dealers there.
Did you see the defendant and his +1, Charlie Gibbons, at the party?
Yes, I actually arrived at the same time.
What was your first impression of Charlie?
Not a good one. He had wrinkled clothes and he seemed nervous.
Would you say that he looked stylish in his trench coat?
Absolutely not.
Did you see the defendant, Evan Shem, during the fireworks?
Yes.
Will you please explain on Exhibit C? Where were you when you saw him?
I was in the foyer,
And where was he?
coming out of the hallway from the gallery.
Was he carrying anything?
No.
Did you see him holding a backpack? No. No further questions on it.
Boss?
Yes, Your Honor.
Once more, for scoring purposes, my name is Judson Olagi, O-L-A-G-U-E. You stated that you knew the defendant before the party, correct?
Yes.
And you had a high opinion of him, correct? Isn't it true that the night of July 4th, the defendant told you that they would sketch a scene of the party?
Yes.
Isn't that why the defendant had a backpack with them?
Yes.
What was the last time you saw the defendant during the party?
I don't recall.
Sorry?
I don't recall.
Would you like me to remind you?
Yes.
On page 40, line 13. And where was the defendant when you saw him? Would you like to see?
Out of the hallway, going out of the hallway from the alley.
At this time, did the defendant tell you that their sketch was going great?
Yes.
I imagine it would surprise you then to find out, in fact, that the defendant would have lied to you and did not sketch a scene of the party. Thank you, Your Honor. No further questions.
Redirect, John.
Yes.
Please reiterate, when you saw Evan during the fireworks show, did you see him carrying anything?
No.
Did you see him carrying his backpack?
No.
No further questions. May the witness step down.
Yes. Any further defense witnesses?
The defense would like to call Sydney Ogden to the stand.
Do you solemnly affirm that the statement you are about to give is truthfully and truthfully conformed to the facts and rules of the mock trial competition?
I do. For scoring purposes, my name is Emily Gomez, Gomez, and I'll be playing Sydney Ogden.
May I have a final answer?
You have 5 minutes and 37 seconds remaining.
How did you first become friends with the defendant, Evan Shem?
Well, we became close friends sophomore year in drama club.
What do you remember of your relationship with him during this time?
He is an honest person and very reliable. And if you were to trust anyone with something that's worth millions of dollars and is like a family to him, it would be Evan.
Did Evan tell you about his internship at the McCullough Gallery?
He did, but
Objection, Your Honor, this testimony conveys hearsay as to why Evan Shem would tell Sydney Ogden of his internship.
And
I'll overrule that objection. It asks, did he tell, not what was said. Yes.
did he tell you about his internship at the McCullough Gallery?
he did, but very briefly.
Against a better judgment, what did he tell you?
Objection, Your Honor, this testimony contains hearsay.
That sounds like it does, but I'll hear what you have to say.
Hearsay is in regards to when one of the parties are present in a conversation is not available for testimony, and we have both Sydney and Evan present for testimony.
Hence,
Your Honor.
it calls for an admissible hearsay, does it not? Well, I say it does, so objection is the same.
Just to clarify her objection.
To sustain, meaning I'm not going to allow the answer to
Okay.
my question.
Why were you at the 4th of July party?
My company was there working, so I was working for the selling.
Where were you during the fireworks display?
I was by the public porch.
Would you please indicate on diagram C where you were standing?
Right.
Could you see the fireworks from where you were?
No, I had a train to watch a glimpse of them.
What could you see?
I could see the massive living room and the kitchen from the glass wall.
The fireworks are about to begin. Where is Charlie?
Charlie is by the back of the crowd, near the kitchen and the living room.
A few minutes into the fireworks, was Charlie still there?
No, I see him leaving the hallway, which was strange.
What was he wearing?
He was wearing a tan trench coat, which was strange.
Objection, Your Honor, this testimony contains speculation as to why she thought it was strange why he would wear a trench coat.
May I respond, Your Honor? On a beautiful summer night, would you wear a very large trench coat?
Your Honor, may I respond? It is not to why he would wear a trench coat on a beautiful summer night, but she thought it was strange, and so that is why I was objecting.
And it sounds to me like that is a fruitful subject for cross-examination, so I'm going to overrule the objection.
I will ask the question again. What was he wearing?
A tan trench coat, which was odd since it was a summer night.
No further question.
Your Honor, may I cross-examine the witness?
Yes.
And for scoring purposes, my name is Marinel Rosero, spelled R-O-C-E-R-O. The prosecution calls for a time check.
You have 5 minutes remaining.
Good evening, Ms. Ogden. So where were you on the 4th of July party?
I was by the covered porch attending party.
So did you see Evan leave to go to the gallery?
Yeah.
So how long have you known Evan Shen?
Well, we've been best friends since sophomore year.
So you were acquainted with Evan Shen and Charlie Gibbons, correct?
Correct, even though I wasn't that close to Charlie.
So, isn't it true that you spent every waking moment together in high school with Evan Shen?
Correct.
So you admire him, correct?
Correct.
So, were you close to Charlie Gibbons?
Objection, Your Honor. This is beyond the scope of, oh, I'm so sorry, I forgot. It doesn't apply to cross-examination. I rescind the objection.
So rescinded.
Were you close to Charlie Gibbons at all?
Not really.
And wouldn't you say that Your Honor, never excuse me.
Yes.
So, isn't it true that you never saw Charlie Gibbons mingling with the wrong crowd?
Correct.
Your Honor, may the witness please approach Exhibit C.
Yes.
Ms. Ogden, could you please show the court where your location was during the party?
I was by the covered porch.
And where did you see Charlie Gibbons before 9 p.m., before the fireworks display had started?
Over by the crack in the living room and in the crowd.
And could you please show the court where you saw Charlie Gibbons after the fireworks display started?
Of course. He was leaving the hallway.
Ms. Ogden, wouldn't it be impossible to have seen Charlie Gibbons from the covered porch leaving the gallery leading into the hallway?
Objection, Your Honor. Creation of material fact. There is no evidence in any of the witness statements or stipulations given by the court that there is an obstructed view from the covered porch.
Your Honor, may I respond?
Yes.
It is reasonable inference because in Professor McCulloch's testimony, he had stated it is his estate, it is his house, he has lived in it. So it is reasonable inference that she could not see him, for there are covered walls covering her peripheral, covering her peripheral from the gallery leading to the hallway.
May I respond, Your Honor?
I don't think that's necessary. That may have been the statement, but I didn't hear testimony about that at trial. I'm going to sustain the objection.
Thank you, Your Honor.
No further questions, Your Honor.
May I read your?
Yes.
Prosecution asks, did you spend every waking moment during high school with Mr. Shen?
Correct.
And you had previously testified that you found him to be, pardon me one moment, that you found him to be reliable and honest.
Correct.
would you say that he is the most reliable and honest person you've met?
Correct, yes.
Will you approach Exhibit C, please? You saw Gibbons leaving the hallway. Will you please explain to the court what is adjacent to the hallway?
Adjacent to the hallway would be the gallery.
No further questions, Your Honor. The defense rests.
Okay, witness may be excused. No further witnesses. I think we are ready for some closing arguments.
Before I begin, may the prosecution have a time check.
You have 4 minutes and 31 seconds.
For scoring purposes, my name is Stephanie Barrow. Your Honor, we are here tonight because Professor McCullough almost lost her most cherished possession, treason. The defendant almost got away with this horrendous crime, and because he did not, he is now trying to pin it on somebody else. The defendant is the only person who has the means, opportunity, and motive to commit the crime. The defendant had the means to steal treason or replace it with a replica for 3 different reasons. First, the defendant stared at treason almost every day. We have heard from Gibbons, who stated that the defendant could replicate paintings from memory. Since the defendant stared at treason every day, it would have been quite easy for him to replicate treason. Second, the accused had access to the gallery. According to Professor McCullough, the defendant is the only person besides herself that had access to the gallery. And third, the defendant is an exceptional forger. We have heard from multiple witnesses, as well as the defendant, who stated that Shem would be quite capable of creating a perfect replica of treason. The defendant also had the opportunity to replace treason and replace it with a replica. On the night of July 4th, Professor McCullough asked the defendant to be a docent for the evening. This gave Shem the perfect opportunity to steal treason. When everyone was distracted by the fireworks, the defendant snuck in, stole treason, and replaced it with his replica. Witness testimonies confirmed the seeing Shem running through the gallery clutching his backpack. When questioned about the backpack, the defendant lied and stated it was being used to carry art supplies around to sketch a picture. When asked about the sketch, the defendant lied again and said that it was being used, that the sketch was going great, although the defendant admits never having painted a picture. There is no reason for the defendant to lie about the sketch unless the backpack was not being used for what he said it was going to be used for. The defendant used this backpack to carry the replica treason in and used it to carry the real treason out. The defendant is the only person who had motive to commit this crime. At the time of the crime, not only was the defendant in college, but he was also planning on attending graduate school. He estimated the cost would be $125,000. He was worried about paying back this outrageous amount of debt because he knew that he couldn't afford it. This is why he took the internship with Professor McCullough, because she promised that this would eventually become a paid position. When this promise of payment never materialized, Shem admitted to being angry with her. The only reason he took this internship was because of this promise of getting paid. While working for McCullough, the defendant became specifically interested in treason. He even admitted to calling MT's Fine Art Auction House to find out the value of treason. Although the defendant states that he called to find out the value of treason, we have heard from 2 witnesses tonight who overheard this conversation and say that he was interested in selling treason. As soon as the defendant found out that the painting was worth $100,000, he came up with a plan that would not only get back at McCullough, but also pay back a substantial amount of student debt. Although this painting was not the most expensive painting in McCullough's home, Shem was obsessed with it. He even stated that it had a hypnotic quality to it. As for the painting found in Shem's apartment, Worcester authenticated that this is the real treason. After a thorough investigation, he decided that Exhibit A was the real treason. Worcester stated that Yazdi's artwork is known for its harsh and vigorous styles. Exhibit B looks too carefully applied, like the artist had to keep stopping to examine his work. He also stated because of how the artwork was framed,
it's been quite easy for the defendant to replace treason with his replica. Your Honor, tonight we've proven beyond a reasonable doubt the defendant is guilty of theft by larceny. He had the means, opportunity, and motive to commit this crime. The defendant stole treason without McCulloch's consent. The value of the painting is over $950, and he intended to sell treason to the highest bidder. Thank you, Your Honor.
Defense.
You have heard from the friends, professors, and art experts, but what some of them have failed to tell you is proof. Bernie Worcester claims that he can identify a fake from the authentic right away. What Bernie Worcester failed to do was base his conclusion off of facts, and he based his conclusion off of facts that cannot be proven. The prosecution stated proof that cannot be proven. You have heard from Jamie Sardegna and Bernie Worcester. They both use the same method of authenticating the fake from the original. The difference between the two is one has seen the treason beforehand and one has not. Jamie Sardegna has seen the painting treason beforehand and would know what the painting looks like before it came upon her intention. Bernie Worcester, on the other hand, has never seen the painting before and cannot come out with a conclusion without facts. Bernie Worcester claimed that there was vigorous style of paintings in other Yazoo paintings, but that did not refer to this particular painting treason because he had never seen this particular painting before. It is beyond a reasonable doubt that Evan Shem could have committed the crime. And there is reasonable doubt on the prosecution side because there is no proof and no evidence and no key witnesses that states that my client Evan Shem has stolen the painting treason. The painting treason located in McCulloch's gallery is the authentic treason by the Fletcher Yazoo, and the painting located in Evan Shem's apartment hanging on his wall is the fake. Thank you.
Rebuttal?
Yes, Your Honor. The defense states that Sardegna was able to identify Exhibit B as the real treason because she has seen the painting before. Although she has seen the painting before, she has only seen the painting once and for a very brief amount of time. How can she clearly state that Exhibit B is the real treason if she stated that most of her tests were inconclusive? Worcester had a thorough investigation, and he was able to determine that Exhibit A was the real treason. And although we had no witnesses actually see Shem steal the painting, they all say that he would be the most likely to have stolen the painting. Your Honor, the defendant should be found guilty of theft by larceny. Thank you.
And the defense.
Likely is a term used by the prosecution, but can in no way be proved that that is the case. And the prosecution has also stated that Jamie Sardegna has only viewed the painting treason once. But once is more than enough to determine if a painting is true or not. And Bernie Worcester, on the other hand, has never seen the painting treason. And once is more than enough. Therefore, my client is not guilty. Thank you.
Thank you. I will deem the matter under submission. Why don't you guys give yourselves a round of applause? Everybody can breathe again. their sheets, and then I will announce the verdict, and we can stick around for a couple of minutes, but of course there's another round to get to. Let me say this. I want to acknowledge and thank the teacher coaches and the attorney coaches for the teams. We no longer introduce each other, so the judges and nobody knows what teams, but I know just how hard you guys worked and how hard the attorneys worked to volunteer their time, and the teachers long after hours. Your work is not unrecognized, and it is greatly appreciated. That's number one. Number two, I say this every year. I'm going to say it now, and you know it's just going to roll off you like water off a duck, but it's important to say, and maybe this year somebody will believe me. The verdict doesn't matter. The ruling on the pretrial motion doesn't matter. This is a scored competition based on knowledge of the facts, poise, thinking on your feet, all those things. They write these things up, so both sides have something to argue, and both sides have good things to argue. The problem is when that bumps into a criminal case, and the rules, as you all know in here, person is innocent until proven guilty, must be proven by guilt of beyond a reasonable doubt. When there's two reasonable interpretations, a court must adopt the interpretation that points to innocence. That means it's always, the way they write these things, a very tough road to hoe for the prosecution. I've been doing this for many years. It's perhaps even tougher than usual. So based on the fact that we have dueling experts, based on heavily circumstantial evidence case, I am compelled, based on that, and again, not a reflection on performances or anything, but I am compelled to find the certainly suspicious looking, but in this case, not guilty, Shem. So that is my decision. We have just a few minutes, so I'll talk quickly and then turn it over to the scorers. It's always tough the first week. You're so nervous. It gets so much easier as you'll go and you'll see that. Attorneys, study your evidence, though. Okay? You can always stop a team right in their tracks with a well-placed objection. Witnesses, you're adopting your personas. Keep reading those statements. You can't read them too many times because you know there's going to be an attorney trying to catch you up on it. But you guys are coming along. You're doing great. Let's hear what our scorers have to say.
I second what the judge says. I'm going through a little time warp because the last one of these I judged were the state finals, and the two teams I judged were third and fourth in the state finals. And what he's saying about objections really rules. They ran an objection. So study the facts and make sure your objections are solid. Secondly, I think developing scores is really a teamwork between the attorneys and the witnesses. And you should practice together so you get, there's really a team. So they know the questions and the answers, and you know the cross-examining them. The smoother that goes, and the more provable, the more honest the witnesses are, or indignant if they're cross-examined. That really helps in the scores like that.
Okay, so I thought all of you did a good job with your voice and your projection, which I think is really important, that you need to project that you are confident in what you're doing. And I thought all of you, including the pretrial motion attorneys, did a really good job with that. It seemed like you were all able to talk without notes, and I think that was impressive, that you knew your arguments and you were able to talk without notes. And you need to listen really carefully to what actually comes out. So even in a real trial, you may have all these statements, but what actually is testified to in court can be different than what the statements say. So when you do make your arguments, you can incorporate things that people said in court, but you're going to have to drop out things that maybe didn't get covered in court. So along that same line, it works well to kind of plan out your argument and then work backwards. What facts do you have to establish in order to make that argument? And then you should write an outline that I'm not going to let this witness off the witness stand without establishing those facts. The closing arguments I thought were good. You guys need to use the law in your closing arguments. So it's really important, especially for the defense, beyond a reasonable doubt. It's huge. It's huge. And in court, we argue that in front of a jury all the time because it's a really heavy burden and they haven't made their burden. They've got a tough case here to make that burden, so you really got to hammer that, you know, you can't find my client guilty. You might have a suspicion, but you don't have proof beyond a reasonable doubt, and that's really important. And for the prosecution, we have to go over like each step. This is why you should find him guilty beyond a reasonable doubt. So you always use those words. We're asking you to find him guilty, and on the defense side, we're asking you to find that he's not guilty. The prosecution has not established beyond a reasonable doubt that Mr. Shem is the one who stole the painting. So you guys, it's a lot of work, and I know the first night is really nerve-wracking for everybody, and it'll get easier as you go on, but you did a really good job.
So, one more round of applause. 30 seconds.